All right, welcome. We are so glad that you could join us today. My name is Steve Smith. I'm co-founder and CEO of Intellispark. My parents were both educators. I've worked in education for almost 30 years, and so I'm incredibly appreciative of your work. Today, I'm joined by our general counsel, Stephen Goldman. Stephen, can you introduce yourself?
Sure, thank you, Steve. So I've worked as a lawyer in the education sector for about 29 years now. I've worked and have experience in the primary, secondary, post-secondary, and educational technology areas. And in addition to being responsible for litigation, I've also had extensive experience on issues facing education markets such as privacy, data security, and the emerging field of artificial intelligence. And I'm looking forward to talking with you today. Steve?
Excellent, thank you. So today, Stephen is going to be sharing some of his expertise from decades of practicing law in the field of education on a topic we know generates a lot of questions, specifically legal considerations for tracking and sharing student support information. At Intellispark, we help hundreds of public and private schools across the US to do this, including many of you on this call, both to improve the delivery of student support services and to ensure educators can track and share information in a way that complies with relevant local, state, and federal requirements. If you're interested in learning more about Intellispark and the solutions we offer, please reach out to me at stephen.smith@intellispark.com or fill out the Contact Us form on our website. This session is being recorded, and we'll send the video link within the next few days to everyone who registered. We'll also email a certificate of attendance to those who joined us live. Please don't hesitate to pose any questions you have in the Q&A. I'll do my best to moderate that list for Stephen. And with that, we have a lot to cover today, so I'd like to pass the floor to Stephen, who will take it from here.
Okay, so here's what we're going to cover today. Obviously, we've already covered introductions, and I'll spend some time on general principles that are related to record keeping regarding students, then go over about 4 or 5 legal myths that exist in regarding student record keeping, and then as Steve said, we'll have some questions and answers. But if you can go to the next slide. I wouldn't be a good lawyer without offering a legal disclaimer. So here it is. In short, I'm not your attorney. I'm not an attorney for your employer. I'm not providing legal advice. What I'm doing is providing educational information for all of you. And I understand that you may be at different stages of developing your program and that you may be in different environments, such as school districts, charter schools, private schools. I will assume that you have a general working knowledge of FERPA, but by all means, please feel free to ask any questions for more elaboration about any issues or for more in-depth information. A lot of what I'll discuss is going to be based on state, not federal law. So what I tell you will generally be true, but maybe not in your state because you may be in one of the states that has exceptions. Okay, next. I used to keep this on the back of my computer when I was in an office to always remind people meeting with me, be careful about what you write down. Now, that doesn't mean don't keep records. Records are a necessary part of any business, including schools and private schools. They help us establish that you've met the care of the duty of care that you have towards your students. They ensure communication when needed. They reduce the likelihood of forgetting key facts and avoid disagreements later because people may have different recollections that you can clarify by going back to the documents. But most importantly, they will help you help students and families. Thank you. Next. So what is a record or a document? I'll use both terms interchangeably. And basically a record or a document is pretty much anything except for thoughts, observations, audio, or any other sensory perception if those are not recorded or memorialized. And it doesn't matter what kind of medium they might be recorded or memorialized in. It could be old-fashioned pen and paper. It could be in an electronic medium. could be an audio recording, text, instant messaging, videos, any of those, and I'm sure some that have not been invented yet. Keep in mind when you think about documents, especially electronic documents, what I'm referring to, that hitting delete does not actually delete the record. All it is doing is eliminating the address for the record, so the computer could normally easily find it. It's just basically deleting that address and marks the space as available for overwriting and reuse. But until something actually overwrites it, it's still there somewhere on that hard drive or other medium that's saving otherwise saving the document. Next. So there are many different ways that you might get a request for documents. One is through FERPA's right to request documents. The owner of the FERPA rights has that right, only the owner of the rights, not anybody else. Typically, in the K through 12 sector, that owner is going to be the parents, including both parents of divorced or separated couples, unless a court actually puts in a court order that so-and-so does not have the right to education records. If the student is at least 18, then that student would actually be the holder of the FERPA rights at that point. There are two exceptions that are relevant for documents that need to be disclosed under FERPA. Those are sole possession records, records that you might keep on a pad of paper or electronically, but just kept for yourself as an aid to your memory. And also there's an exception for health records if your school district has designated health records in its FERPA policy, and if they're truly being treated as health records. Open record requests is another type of request for documents that you may see. This really only applies to public entities, charter schools, school districts, other local educational agencies. And one thing to know about those open record requests is that they would exclude actually the information that's protected by FERPA. So while people can request records, typically whoever is fielding that request is going to have to exclude everything that is covered by a FERPA. Government requests and administrative subpoenas. The might get letters from government agencies or what's called an administrative subpoena, which is issued by an agency, not by a court. Whether those are mandatory or enforceable turns on the statute that authorizes the request for the subpoena. And sometimes you may find that government agencies, intentionally or not, go beyond their authorization. So it's probably wise to check with legal counsel whenever you get these kinds of requests. Just as an example of something that goes beyond authority, ICE has been issuing administrative subpoenas, which it has the right to do, and including a statement in them that they need to be kept confidential. ICE actually has no authority to require confidentiality in those subpoenas. Litigation discovery, including judicial subpoenas, is a fourth category of a source of record request for documents. Basically, anything that is relevant to the litigation is quote unquote fair game to ask for and have produced in litigation. Exception for some privileged documents, and we can get into some of the details of those. But the way it's phrased under the federal law is any non-privileged matter that is relevant to any party's claim or defense and proportional to the needs of the case is essentially fair game in the litigation. State rules, if your litigation is in a state court, will vary. They're similar, although the exact wording may be a bit different. Next. There are several different types of legal risks: regulatory and compliance legal risks, basically statutes and regulations that are promulgated by federal or state agencies. Data privacy and cybersecurity really is a subset of actually all of these other three, but increasingly important. Contractual risk exists as well, because you could undertake an action that violates a contract and possibly subjects the school or school district to liability. And of course, legal risk, you presumably do not want to, would prefer not to see your district or school in litigation, although it's inevitable at some point for any school or school district. There are ways to mitigate all of these risks. You can conduct risk assessments. You can't know what risk you have unless you go and take the time to determine whether the risk exists, both as far as the frequency of the risk, is it highly likely to occur or unlikely to occur, and to look at the potential severity. Is it a bet the school district case, or is it something that may result in a nominal fine? You can also mitigate risk by developing policies and procedures. Make sure you train people and keep people aware of those policies and procedures. Monitor and audit your practices, such as maintenance of special education records. Insurance for some public institutions and all private institutions, another way to mitigate not the existence of the risk, but the impact on the institution. And timely involvement of legal counsel will always help litigate the risk once you have one of these, or at least keep the risk in check once you have one of these undergoing. Now, I don't want to overstate legal risk, because equally important are reputational and public relations risks, especially to schools and school districts. People trust their schools and school districts generally, and we want to maintain that, and you want to maintain that trust. Just in case there are some questions about institutional risk versus your own potential personal risk, as a general matter, if you're acting within the scope of your responsibilities of your job, you will not be personally liable. Now, does that mean you can't be sued? Nope. It was the easiest question to ask any lawyer is, can I be sued? The answer is always yes. Anybody can sue anybody else for anything. It doesn't mean they're going to win. There's even been at least one suit brought against Satan and his staff. I don't know how large his staff was or is. The case was dismissed because the court decided that it had no way of serving Satan. There are several cases against God. They were also dismissed for similar reasons, but it just goes to show that a case can always be filed. Doesn't mean somebody's going to win. Another factor that weighs against individual liability is a qualified government immunity that most or all public school employees and public school districts have for actions taken in good faith. Another way that weighs against the personal liability is a good faith reliance on a written school or district policy or instructions from superiors, preferably, frankly, an instruction in writing, because that way you can prove it was given. Factors that weigh in favor of individual liability include ethics violations. If you violate an ethics rule, that's yours to own. Conflict of interest violations, similarly. Other violations of some statutory duties, such as mandatory reporting, ADA, the Americans with Disabilities Act, and Title IX. Move on to the next slide. I do want to take a few words, a little bit of time to give a few words about artificial intelligence, because it's such an emerging field. Everybody seems to want to use it. but they may not be aware of all of the risks and pitfalls, especially when we're talking about artificial intelligence that's available, off the shelf, basically to anybody on the internet, whether it's free or paid. Because generally, the terms of use for those engines state that all inputs and all outputs belong to whatever company is providing the artificial intelligence engine. And they usually also say that they can use those inputs and outputs for training their artificial intelligence machines. And that, not surprisingly, is inconsistent with both FERPA and state student data privacy laws. Security, data security is also very important with artificial intelligence, just like for any other type of software that houses any kind of information, really. In March of 2023, ChatGPT reported that it accidentally leaked some person's first and last names, email addresses, payment addresses, and the last 4 digits of credit card numbers. So artificial intelligence are subject to the same types of data security concerns as are any other type of software. Intellectual property is a concern. I've never tried it, but I assume that it's possible with AI to input a rubric for grading student essays and then put student essays to grade according to that rubric. That would make your life easier if you're a teacher. But under the typical terms of use that I just mentioned, that would be inconsistent with FERPA and may also be inconsistent with the student's copyright in the work that they wrote. Because once something is put into some kind of tangible or electronic form, it's automatically copyrighted. You don't have to register something for it to be copyrighted. Accuracy and hallucinations, you've probably read by now, are a big problem with artificial intelligence. All AI is doing is predicting the next word. It's not truly intelligent. And also, many AI machines are updated only to a certain date for training purposes. So anything that happened after that date, the AI has no clue about. AI may rely on inaccurate websites. The old saying, garbage in, garbage out, comes to mind here. One very unfortunate instance of poor output, I guess, from artificial intelligence occurred when the National Eating Disorders Association had an AI chat box on its website. In 2023, it offered bad advice to some people, such as that people should count calories for healthful eating. Now, the association quickly took the chat box down, but that's just an example of unintended consequences. And there's also algorithmic bias. What is the information being fed to the tool that will bias what the outputs are? And whatever software developers put into the tool as far as how they want the AI tool to react, that will also bias it. A lot of the tools now are being built with some kind of encouragement to the tool to be more engaging and keep people more involved in the AI tool. And so there are increasing reports about people being sort of dragged into these artificial worlds. If you're using any AI tools for summarizing meetings or taking notes, definitely keep all this in mind, because you don't want to inadvertently put something out there that may wind up being owned by somebody else or be inaccurate. Next. So what are some of the best practices for creating records regarding student information? Of course, keep the tone professional. You don't want to be mean or demeaning in the records. That does not come across well later on if a judge or a jury reads it or a parent reads it. Make your point, but don't overemphasize. Try to avoid putting everything in all caps, underlining it, putting it in bold, and putting 4 exclamation points after it. Always consider the purpose of the record. Why are you making it? And the audience of people that it's intended for, maybe colleagues, maybe others, maybe the student, but also keep in mind possible audiences that may see it even though they're not the intended audiences, parents, judges, juries. You always want to come across as professional and not go overboard in the records. Generally, I think it's better to stick to the facts when you're creating records. Not always. If opinion is appropriate to a record, state the basis for the opinion. I believe X because whatever. Identify it as an opinion, so it's clear that you're not stating it's a fact. And don't give opinions that you're not qualified to give. I'm not qualified to diagnose anybody as a narcissist. I'm not a medical provider, so I would be remiss if I stated somebody as a narcissist. By the same token, unless you also happen to be a lawyer, don't reach legal conclusions because you don't have all the information necessary to make those conclusions. It should be obvious, be accurate in what you write down. Be careful about using quotation marks. If what you're really doing is paraphrasing what somebody wrote, better off not to use quotation marks. What else? State what was done because of whatever conversation you may have had, and state what will be done or what you're recommending to be done, and make certain that it's done in a timely manner. And if it's not, it would be ideal to put in a record that says we changed our minds because A, B, C, and therefore we took course A instead of course B. Be certain that the record is only available to the permitted and intended audience. It's vitally important that any kind of software tool you use to house records have access controls to ensure that the records are only going to the intended audience. I think we've probably all at some point in our lives by now hit reply all when we meant simply reply. And if you're using something with access controls, that should prevent that practice or something similar to it. Sometimes it's helpful to record what was not stated or observed. If a student tells you, for example, that they were being mistreated at home or beaten at home, if you didn't see any visible injuries, state that. If you did see visible injuries, state that. It might be useful in some occasions to state that the student made no statements indicating suicidal ideation. You may still draw the conclusion that the student is suicidal, in which case you would probably want to explain that that's your professional opinion based on your years of experience and degree if appropriate, and that this is what led you to that conclusion, A, B, and C. Words matter. Avoid never, always, clearly. And grammar and spelling also matter. That goes back up to the top, keeping the tone professional, because good grammar and good spelling will be indicators of your professionalism and helpful if something goes to a judge or a jury or a parent for that matter. Also use person-centric language. Better to say the student has epilepsy rather than the epileptic student. If you're recording a record that you believe is subject to a counselor-client privilege, it's preferable to indicate that at the top, or at the very least at the bottom of the message. That will, if nothing else, make it easier for people to identify that they need to review it for privilege, and also will hopefully notify recipients of the message that they need to keep it in confidence. Okay, next. So from a legal perspective, what should you look for in a record-keeping system? Well, as I mentioned, privacy is vitally important. The first states to privacy, FERPA rather, has existed since about 1977. Before anybody thought of all these electronic tools, or at least before they were available. And then starting in about 2015, many states, more than half now, have their own unique state student data privacy law that better reflects the online world we live in. So privacy is very important. As a corollary to that, as I mentioned earlier, communication tools should always provide secure methods for sharing data among only authorized users. You want those access controls that can be customized by your school or school district, so it reflects how your institution operates and the institutional needs. Data security, as I mentioned, vitally important. Any system, really, truly any system, no matter how secure, can be broken into given enough time. That's just an unfortunate world we live in. Data portability, you may not be with the same software system forever. And so you want to make sure that the records that are in a system can be easily exported from the system, and so you can use it in another system, and either that there is no charge for that, or if there is a charge, that it's identified upfront and fixed. You don't want 5 years from now to find out that a cost has been tripled, for example. And of course, any type of software system, you want support and onboarding and training available for people who are going to be using that system. Okay. So I promised you a few common legal myths about records. One is that the presence of an attorney makes a meeting or a document subject to the attorney-client communication privilege. Attorneys have no mystical powers. You can't just plop us in a room and say whatever goes on there is privileged, or plop us as a CC on an email. The privilege only is created if you're seeking legal advice based on the information in that conversation or record. Otherwise, all you're doing, frankly, is using up the attorney's time, probably costing more to your school or school district if it's an outside attorney, and filling up somebody's inbox. Medical records. Another myth is that all information from a medical provider in a special education record is subject to HIPAA. I know lots of very, very, very smart people who have worked with special education records for decades, and they believe this to be true, and it simply isn't true almost always. Just like with anything, there's always an exception. There's a guidance document between the Department of Health and Human Services and the Federal Department of Education that basically goes out in excruciating detail about this. It's 20 pages long if you really want to read it. It was most recently revised in 2019, but basically it says that these types of records are not HIPAA records, one, because the institution is not a HIPAA covered entity, and two, because any record that's protected by FERPA is excluded from the definition of protected health information. So if it's a FERPA record, it's not a HIPAA record. So I said there are some exceptions. Occasionally there can be an exception if you have certainly if you have a third-party licensed healthcare office that's billing, for example, insurers and Medicare. And for private schools that are not subject to special education for the most part, and therefore have no special education records, if you have a nurse's office or something similar, you're generally at that point relying on the fact that you're not a HIPAA covered entity. But again, if you're billing insurers or Medicare, your health clinic may be a covered entity, and you should definitely talk more in depth with that about that with legal counsel experienced in preferably both HIPAA and student records. Personal records. So many institutions now have bring your own device programs where they don't give you a phone or a BlackBerry, but they expect you to stay in touch using your phone. Your personal electronic accounts, your own personal Gmail account, for example, and your own physical devices are all potentially subject to discovery and litigation about your work. There's no protection just because it's your own device or your own account. The only way to avoid that is to not put information about work in your personal account and not use your personal device for that, if that's a possibility with your employer. And then another myth about record keeping is, we can just keep these forever. There's no downside. There actually is a downside, several downsides. First of all, you're going to increase storage costs. Storage is pretty cheap now, but it's not non-existent. At some point, you'll come to a point where you're going to wind up increasing your record retention costs. Also, you're potentially widening the scope of discovery. If there are more records, there's more that you may need to sift through to find out if something is relevant. You're also creating a greater breach surface. So if you have a breach of security and you have, I'm just making up numbers, 1 terabyte of information, that's less exposure than if you have 500 terabytes of information. And also at some point you may start slowing down system performance. So there are real world consequences to keeping records forever, and that's not the best ideal. Most states, for the public school districts, most states have their own very specific record requirements, record retention requirements. If they don't, your local school board association may have templates, or work with legal counsel. Private schools can work with their legal counsel about this, and the way that those record retention policies should work is you keep record types X, say financial records, for 7 years, and then you destroy them, all of them. Yes, with one caveat, there's always a caveat. If something is involved already in litigation, your attorneys will send you what's called a document hold notice saying, no matter what, don't destroy this until we tell you it's okay. Next slide. Time for any questions. As Steve said, he'll please off.
Thanks, Stephen, for all of that information, and clearly just a lot of important details to consider. There are some questions that have already come in, and so I wanted to first just open with the most recent, which is you made mention of personal records. There being a myth that personal records are somehow shielded from discovery or disclosure in a discovery process. So when you talk about personal devices, like let's say somebody has a personal device where they also access their work email, how does the access of work resources from a personal device affect the discoverability of other information on that personal device, if it does?
So great question. Again, let's assume the information in the account is relevant to the litigation. Typically, the first place that opposing counsel would want information from is from that account, not necessarily from your device, because doing that is expensive, intrusive. Generally, that would not be allowed. But if the case is serious enough, or if they have reason to believe that something is extra, is somehow hidden on your device, they may ask a court, for permission to have your device on a temporary basis, give it to an expert, and have the expert essentially go through it. Doesn't happen often, is possible. I think that
Great.
answers that.
Yeah, thanks. So going back earlier in the presentation, I liked your slide about dance like no one is watching, but keep records knowing that somebody could be seeing those records in the future. Are there any records that I keep that are protected? And let's assume that I'm a professional counselor, that I have a license. So how might that affect the discoverability of records?
Another great question. So every state has some version of a counselor-client privilege. They may call it something different. They may call it therapist-client privilege, but that type of thing. Generally, the information in those records will be protected by that privilege and not discoverable. But again, as with pretty much everything in the legal world, there are exceptions. Certainly if it's related to your handling of information, your use of the information. If, for example, a student died by suicide and the parent is claiming you should have known about that possibility and didn't tell anyone, that those records become relevant and will wind up being disclosed. Generally, courts will use a balancing test. How important is the need for that record, for that privileged record, compared to the needs of the case? And so it's going to vary on a case-by-case basis, and it's going to vary on a state-by-state basis because different states tweak that in different ways.
Can I ask a follow-up, Stephen? So you described how it's a myth that an attorney being part of a conversation extends privilege to others in the room unless there's a legitimate reason that you might be seeking legal advice. Does counselor privilege work the same way?
Yes, absolutely. Not every conversation between a counselor and a student, or a counselor and somebody else is going to be privileged. They have to be for purpose of getting some kind of counseling. You're banter in the hallway. Hi, how you doing? Oh, I'm doing great. I'm going to the game tonight. That doesn't sound to me like it has anything to do with a counselor-client relationship, and it's not going to be privileged.
So a couple questions related to confidentiality have come in. And these, I think the context for both of these are have to do with sharing information with colleagues within a school. So in the first question deals with a licensed counselor who's interested in the sort of limits of confidentiality, both verbal and written confidentiality, if they share information that's need to know with others on the staff in the school. So I guess, are there boundaries to what a counselor could share without risking their licensure status?
So partly this depends, again, on the state, depends on the law of the particular state. But for example, information that the counselor discloses to an IEP team, you're able to do that without violating confidentiality for IEP planning and IEP implementation. If a student tells you about that they were sexually assaulted by someone in the school or school district, Title IX actually requires you to disclose that to your Title IX officer and perhaps to the police. There are some other state-based exceptions that apply to school counselors, for example, related generally to the student's safety or to truancy.
So
there are other ways to handle this that maintain confidentiality, but provide some information. For example, de-identifying the information, make it clear that there's no way the receiver of the information can identify the specific student. That's potentially a problem. That may not be what you want. Another way is to provide very general information about the student's behavioral or academic needs, such as, John Madison disclosed to me a recent family conflict that's contributing to occasional absenteeism, and therefore I recommend that we do X and Y. You're not going to go into further detail about what that conflict was, but you can provide that minimal information, and in most states, still be on the protected side of confidentiality.
Just extending this conversation about confidentiality specifically to deal with information about a medical condition. And so if a counselor's in a situation, or a nurse is in a situation potentially where they're aware of an injury, concussion, that might affect a student's readiness for school, or at least ability to function at a expected level in a class. Are there any concerns related to FERPA or HIPAA in terms of sharing that information?
So HIPAA, as I mentioned, generally is not going to come into play, except for those little exceptions where a clinic is, or a school nurse is billing insurance companies electronically, by the way, or billing Medicare electronically. In that case, it may be considered one of the HIPAA covered entities, but generally it's not going to be a protected by HIPAA. Of course, FERPA has that health records exception. So if your school is designating health records in its FERPA policy, generally at least some degree of health records can be disclosed, and also that type of information that you're talking about may be disclosable as related to safety or academic needs of the student, again, depending on the state's law.
So from a federal perspective, you feel like that's covered in FERPA, that disclosing this information, as long as the recipient has a legitimate educational interest in that information, that's reasonable, but that there may be some state regulations. Okay.
And as long as the school district or school has dotted its I's and crossed its T's with the information it needs to provide about health records.
Yeah. Appreciate that. So I want to come back to this question broadly. There's a couple questions that have come into the chat, and also we had received a few in advance of the session today, dealing with given these risks that exist of information in records that you keep becoming the subject of discovery later. What in addition to just the guidelines that you provided, like about being professional and accurate and sticking to facts in your messages, like is there are there any considerations that come into play if you're not keeping appropriate records, if you're not keeping records that you might reasonably be expected to have in your professional capacity?
A lot of that goes down to, how do you prove that you did what you needed to do to fulfill your duty of care? If it's not in a written record that was created roughly at the same time as the event, it's going to be essentially he said and he said, or she said and she said, or whatever. Memories fail over time. Litigation may not be filed literally for years. I've worked one place where there was a student who was in a summer camp about 10 years previously and didn't bring suit until, again, 10 years after the events. Maybe there were records at the time, but nobody could find them, and nobody who was involved in the circumstance was there anymore. So it was difficult to show unquestionably that the right thing was done.
So in that case, a benefit to the institution is essentially having auditable set of records that whether they exist in
Absolutely.
electronic form or in paper form, something that demonstrates that the school did provide the level of service that it was expected to
Yep,
provide.
absolutely.
Okay. We have a question here, maybe out because I know you don't practice law in Illinois, so this might be too specific, but it speaks to a situation where if a student reveals something to a counselor at school, in this case, the question is about if the student reveals to their counselor that they're pregnant, can you or must you disclose that information to a family? And so maybe we can generalize this a little bit. Like, are there situations where counselors would have a requirement to disclose information, either to a family or to others in the school?
This topic, along with, I wish I could answer, I truly do, but first of all, I don't know Illinois law. And it's an area that really is in a lot of transition as different states pass different laws regarding student privacy and regarding parental rights. Sometimes, often they involve related questions related to transgender students, but they may also relate to questions about pregnancy. It's really in flux. And all I can say is that that may be confidential in your state, and it may not be. And frankly, the answer may be one way today and a different way a year from now.
Understood. Just if there are other questions, please do go to the Q&A. We have time for probably 2 more questions. I have one that had come in beforehand. So as we see if there are others that may come in, Stephen, I'm just curious, if there's any distinction, thinking about how you translate the general principle of privilege that exists, whether between an attorney and a client or a counselor and a student, to an electronic medium where you're sharing information with multiple parties. So I understand the concept of a meeting, right, where you're seeking legal advice, you're seeking counseling advice. That conversation is privileged as long as there's somebody who would be eligible for that privilege. If somebody's just copied on an email or copied on a message that's stored in a electronic record system, are there any differences in the way that privilege would apply?
If somebody is copied on a message or blind copied on a message, if they don't have a right to that information, then that privilege is being inadvertently waived. So again, with some of these exceptions relate to safety, truancy, mandatory reporting, special education records, they all need to be records that are disclosed to people who are actually entitled and are required, to receive that information. Otherwise, I would say stay more general, the way I had mentioned earlier, with giving the example of a student disclosing a recent family conflict, and just leaving it at that and saying, I recommend this and that.
Okay. And one last question. So when it comes to maintaining records, is there any difference in your mind or any recommendation that you would have to distinguish between recording a hard copy of records for archival purposes or an electronic archive?
They're all documents and records. They're all subject to discovery, and every discovery request in any kind of litigation will ask for all hard copies, all tangible records, all intangible, all electronic, and it will be a big paragraph in the request for records that will go into every conceivable type of record. So there's really no difference in that respect. One other thing I wanted to mention before I forget about counselors. The counselor privilege applies pretty much to any of, whether you're an LPC or have a master of school counseling or social work. If you don't have one of those degrees, but you're state certified or state credentialed as a counselor, even if you don't have that type of degree, you're generally going to have a counselor privilege in that universe of the school.
Great, thank you. And we'll just wrap up here. And I want to say that there was a comment that came in just as we were answering this last question that pointed out an advantage potentially of having electronic records is the ease of both tracking who accesses them and then making those records available to additional individuals who may need them but work in another building. And therefore, maybe those records are more portable in an electronic form. So I appreciate that contribution. And just want to say thank you to Stephen for sharing his expertise and to everybody for joining us today. So as I mentioned at the start, this was recorded. So please do watch your email for a link to the recording and feel free to pass that recording along to anyone who may be interested but who couldn't be with us today. Our next webinar is going to feature Professor Scott Solberg from Boston University, who will be speaking on the topic of chronic absenteeism and strategies for addressing it. And that's going to come up on October 16th, also at 2 p.m. Eastern. So keep an eye out for that invitation or visit intellispark.com/webinars to find out about upcoming events as well as to access recordings of past sessions. So thank you so much. We appreciate your being here. Hope that you have a great rest of the afternoon. And Stephen, once again, thank you.
Thank you.